lights are ready, no disguises, no confetti. This is truth, no superstition. We don't tell stories, we bring facts, not fiction. Open ears, open mind, what you'll hear is real this time. We are truth on the table, no condition. We are presenting facts, not fiction. We are no fear, no manipulation. We are this is information. Facts, not fiction. No myths. No myths. No superstition. Yeah. Real voices, real information. We are facts, not fiction.
Alma, Libre, Rogelio, you've been doing so fantastic job covering the federal case. Gracias.
Always following us and listening to this program. So what I was mentioning in Spanish was that on March the 10th, on the hearing that was in the motion that they had in the courtroom in New York, was on March the 10th. They put certain dates that they were going to submit motions or on the defense side, and then motions for the government side, and there were certain dates. And yes, on Friday was on April the
10th?
The 10th.
The 10th.
April the 10th. On Friday was the deadline for Nason, Joram's, and Eva's Joaquin's lawyers to submit their motions based on the evidence that they had received, based on the documents that they had received, that they and anything that they wanted to submit any motions based on those documents, and which they did. Basically by midnight on Friday, I did receive a notification that the documents have been submitted, and they were submitted via electronically to the courts of New York, and basically we have obtained those documents, and what we're going to read today, what is their motion and what their arguments are going to be about, that they want to have the court to dismiss. They're trying to dismiss certain things out of based on this motion, and also they are requesting the transcripts from the grand jury.
We're going to get there in a second.
We are not lawyers. We do not give legal advice. We do this as an educational purpose for the audience to know what the documents state and what's being said in the courts. So that's what we try to do in our lives here. We try to read these. We read these documents as they are, and so we do bring that to the audience. So, and the audience, I've always said since we opened up the channel, any document that we read here, we bring here, they are public documents. Anyone can have these can get these documents. Some of these documents are free. All you do is request them. Some of these documents, they do charge for them. There's a public charge to obtain some of these the documents we receive. Either they're documents for the properties that we present in our other lives, or documents that are like these court documents. You do get charged a fee, but they're there for you to obtain them. Anyone can obtain them. So they are not just for lawyers' eyes only, or attorneys.
No, those are other documents that we don't have access to. So no,
they're not
attorneys' eyes only.
AEOs. They're not AEOs. There are some documents that are spaced AEOs, and they're not public. They're not public.
So we don't have access to them.
We don't have access to them. But they are other, like these documents were availability to be obtained. We obtained them. So there we are.
It says Shimon Trufia, hi guys, nice to hear you guys. Es que nos hemos perdido. Sí, Chimoltrufia, así como
we
dice una
have a
cosa,
life. We do
dice
have a
otra
life.
cosa.
We've been with family. Family came to town. We spent time with family. They changed my schedule of work, and we haven't been able to coincide with one another's work schedule. And we want to be here together as a couple. That's how we open up the channel. So just sometimes she's available, sometimes I'm not available, but we were available tonight. So here we are. We were available last night, but I'm a big UFC fan. The UFC,
Yes.
Ultimate Fighting Championship.
That's what it means?
I love watching. Yes.
Oh.
And I love watching you. My
I
UFC.
just know it as
I follow
UFC.
it. I follow every part of that programming. So
Wow.
yeah, last night there was UFC. So
Big fights, I hear.
yes,
They say the best revenge after leaving the cult is to be happy and make up for all the lost time. I'm glad you're prioritizing your family and well-being. Yes, we are.
The process that how we're here today, where we started with how this process to get to the motion of today. She was basically explaining the steps, and she was basically, my wife was basically stating that who are the persons involved there was Nason Joaquin Garcia is involved in this case. We have Eva de Joaquin Garcia, which is the mother of Nason. I'm gonna put the picture so I'm speaking.
Ah, sí, sí. Perdón.
I'm sorry. So this is Nason Joaquin Garcia. For those that are following us, that are new to our channel, he's the one being accused under these documents, and we'll be talking about him. We also have Eva de Joaquin Garcia, which is his mother.
First of all, he's still the apostle.
Also, he is still the apostle. He's named the apostle of the organization, the Luz del Mundo, the Light of the World Church. He's still the apostle. He is named the apostle of that organization. And also we have Eva de Joaquin Garcia, which has also been detained, and she's at Essex, New Jersey, in federal prison, being held in New Jersey for charges that we're going to be reading here in this motion. Also, we have Joram Nunez Joaquin, which is the nephew of Nason and grandson of Eva de Joaquin. So these are some of the key figures that are part of the motion. So they would be reading about them, we'd be mentioning them. And she was explaining that back in December the 10th, the lawyers, Nason Joaquin Garcia's lawyers, submitted a document. This is the document sent to Loretta Presca, which is the judge. They claimed that they had received these documents. They had received 2.2 million documents under a app called Relativity. So they can have, so it's an app that they can use to open these documents, and makes it easier for them to obtain open these documents and go through the documents.
Which on March 12th, they said they weren't able to open a lot of documents and stuff like that.
March 12th,
yes.
they stated that they couldn't. Some of the documents were not being able to open them, but based on these new documents that are received, they have read through those, looked through the documents and seen through the documents, and this is what the motion that they've seen.
Oh, so they were able to open everything
Yes,
according to, okay, because he already read the documents, so this is interesting.
They were
to
able
find out.
to look through the documents and read what was said in those documents, so they are able to, and this is what the motion they see that they put in for the motion they put in for. So they put this letter. They sent this letter back in December, stating that there was going to be what they were planning to do, what the process they were going through. And this is something that usually the lawyers do to keep the judge updated of what they're planning to do, what's for the judge to have a foresee what's coming, what's new. So they try to keep the judge also informed of what's going on. So the judge knows that if any motions are coming or anything that they want to be heard of, they send letters like this that we're presenting, and that they presented back in December the 10th. So, and also
what this letter told the judge.
This letter stated also back in December the 10th, the next page, which states.
Well, here talks about documents, right?
Yes, the documents. That first page was talked about the documents they received and the information they have received, And here is what they propose. They propose that there were going to be that there were as of December 10th, they were looking at 2 future motions that they were basically going to address the court. And one motion was that they wanted the transcripts of the grand jury. They wanted to know what was presented to the grand jury, what evidence that was presented to them. They wanted to know how did the grand jury reach the verdict to submit in it, and the FBI was able to submit an indictment and bring an arrest towards Nason, Joaquin, Nason, Joram, and Eva, and 3 others, which is they haven't been arrested, but they're on they're how do you say they have not been arrested basically, but they are wanted.
Accused?
They are wanted by the FBI, and which is 3 other co-defendants of Nason. But here they mentioned that there was a future where they would be bringing motions, 2 motions. What they mentioned in this letter, and this is what this letter back in December the 10th they submitted. The first motion was that they wanted the transcripts to the grand jury, and second they wanted to be the disclaimer. They wanted it to remove or strike or to remove anything to do with the First Amendment, which is the right to religion. They wanted, so this is what this whole motion is going to be about that we're going to be reading. So what we'll be reading on today is on Friday, on April the 10th, the defense filed the document we're going to be reading today, and they're going to be asking for the transcripts of the grand jury, something that usually, and it's very important here, it is unusual. It is very unusual that they ever let anyone know what was said to the grand jury. That is usually kept a secret. That is usually never given out.
I didn't know that.
That is usually never. So this is unprecedented. This is something that has really in the courts usually is never granted for the defense to even know what was presented to the grand jury.
So they are asking for that. So
But they are asking.
Okay. Déjame lo digo en español rápido.
So the question that we want to know is why they want to know, why they want these transcripts and what they want them for. Basically, that's what we're going to be talking about today. We're going to be reading what the motion that they put in of why they want them and what they want them for. So what we're going to be talking about in these documents is the government says religion is used for abuse and control, versus the defense is saying that religion cannot be criminalized, or defense says that it cannot be criminalized religious beliefs. What is this case really about? That's basically what this motion is gonna be talking about, right? That the government says that religion was used for abuse and control, versus that the defense is saying that it cannot be criminalized, and the religious beliefs cannot be criminalized. Basically, what's been said.
Okay.
So this is the actual document that was submitted by the Nason defense, and is representing Nason, Eva, and Joram. There's another letter, another motion that was basically saying the same, that was also submitted by Joram's lawyers, but I'm going to be reading this one submitted by Nason lawyers. The document that Joram's lawyers submitted is basically the same document, but in resumed in 6 pages. This one's 34 pages, but the document that the lawyers for Joram submitted is also basically on this same it's based on the same information here, but it was in a resume only down to 6 pages. Basically, that's all what they did. It's more in detail. So that's what we're reading this document, because it gives all the details that they wanted to present to the court. And here we go. So we start with page 1, which is the United States District Court, Southern District of New York, which is the United States of America versus Nason Joaquin Garcia, the defendant. Now, notice of defendant Nason Joaquin Garcia's motion for disclosure of grand jury materials. Please take notice that upon the accompanying memorandum of law and upon all prior pleadings filed in this case action, defendant Nason Joaquin Garcia, Mr. Garcia, by and through his counsel respectively moves this court before the Honorable Loretta A. Presca, United States District Judge Daniel Patrick, United States Courthouse, 500 Pearl Street, New York, 1007, at the date and time to be determined by the court, for an order directing the government to produce all grand jury materials related to the instant matter to the defense under the protective order previously entered in this matter. Please take further notice that pursuant to the deadline set by the court at the March 10th, 2026 status conference in this matter, the government opposition papers are due on May the 8th of 2026. So basically this first entry letter is stating that they are presenting, that they are asking, they will be asking for the grand jury
To respond by May 10th.
they're going to be
May.
first they're going to be asking for the grand jury pleadings, what was said in the grand jury.
Right.
Second, they're notifying that the government has to May 8th of 2026
Or to oppose.
to oppose.
Okay.
To oppose. Okay, so that is basically the first part of this. The first part of this letter is what this is,
Okay.
and I'm not going to read where there's a new strategy. There's a strategy that the lawyers are asking for these documents and why they want these documents and why they put this motion. And we're based on, we're gonna read this, as we read this motion, we're gonna see what is the strategy of Nason's lawyers trying to obtain, why they are trying to obtain these documents.
Mhm.
So here's the actual document. The first was just a letter stating proceedings of the court. Now this is the actual document. This is an actual document. The next.
Okay.
So the United States District Court, once again, a Southern District of New York, United States of America, Nason Joaquin Garcia, and defendants, memorandum of law in support of defendants Nason Joaquin Garcia's motion for disclosure of grand jury materials. So here we go. And then next page is the table of contents. Should I read all the content? I'm going to skip the table of contents. Page 8. Okay, let's go to page 8. Memorandum of law.
Yeah.
Okay. Vamos a empezar aquí. We're going to skip the whole, because we're gonna be reading the document. So basically, I don't need why go even through all the table of contents. We're actually going to read the whole document. So we're starting with memorandum of law. Defendant Nason Joaquin Garcia, Mr. Garcia, by and through his counsel, hereby submits the memorandum of law in support of his motion for disclosure of grand jury materials. 1. Preliminary statement. This motion is necessary because the defendant has a colorable basis for a motion to dismiss or to strike significant portions of the allegation in the indictment and needs a grand jury testimony for the purpose of supporting that motion. This base for disclosure is recognized in the Federal Rules of Criminal Procedure and its case law, and it refers to case law. Rule 6 E3 capital E, I don't know how to say this, of the Federal Rules of Criminal Procedures provides that the court may authorize disclosure at a time, in a manner, and is subject to any other conditions that it directs of a grand jury matter. At the request of a defendant who shows that a ground may exist to dismiss the indictment because of a matter that occurred before the grand jury. Grounds for dismissal exist where the indictment rests on a legally invalid theory, and they refer to a case of Bank of Nova Scotia
United,
sorry,
via United
Bank of
States.
Nova Scotia is actually versus United States, and they refer to that case in 4487 U.S. 250 in 1988 article the standard United States versus Peralta, and that's another case, and it's referred back in 1991, dismissing indictment where a prosecutor presented erroneous and overboard legal instructions to grand jury of theory of criminal liability, constructive possession. The primary functions of the grand jury secrecy are kept secret. The identities of witnesses who testify at the grand jury and the subjects of the investigation before they are indicted. United States versus Procter & Gamble Company of 1958, where the identities of those making the allegations against the defendants is already known. These allegations have been the subject of litigation for the past 7 years. The alleged victims have already sued Mr. Garcia twice in both state and federal court, and some have produced and distributed videos and documentaries to air their claims. Here, review of the document, the discovery materials, and the indictment compels the inference that the government secured the indictment by presenting to the grand jury one or more legally invalid theories of liability. These theories of liability contravened one or both of two long-standing pillars of the First Amendment law in lines of cases following United States versus Ballard and Presbyterian Church versus Hall Church. These propositions are fundamental tenets of constitutional jurisprudence and directed apply here. The Ballard rule is that no court or other government entity may make a finding, explicit or implicit, that religious beliefs or doctrine is true or false. Under the Hall Church rule is that no court or other governmental entity may interpreting religious doctrines or whether a particular religious group had adhered or departed from church. So basically, there are citing these several cases here that first of all they're citing the Bank of Nova Scotia as versus the United States, stating that in that case they were able to receive the documents of the grand jury. Okay. And also the state versus Peralta, they also were able to receive the documents from the grand jury. So they're naming two cases that they were able to obtain documents. Then they also continue with here's very important, where they name that under the United States versus Ballard and the Presbyterian Church versus Hall Church, in these cases, the government, they're stating that the government cannot state, that was ruled that the government cannot state if a doctrine is true or false.
Oh, okay. And
also that the government or the courts cannot determine if a religious group is and where it says here under the Hall Church rule is that no court or other governmental entity may interpret religious doctrines or whether a particular religious group has adhered or depended from church doctrine. So the court cannot decide what doctrine
is good
or bad,
okay,
or if it's true or false. That we went on kind of like a little discussion here, was based that here where we were reading here on page 9, where here the identities of those making allegations against the defendant is already known, and we're making the emphasis that they keep claiming that no one knows who these defendants are. I'm sorry, who are the identities of the accused of the victims are. They keep on stating that they don't know who the victims are. These victims are fictitious, and that's what they keep on telling the church, and that's what the defenders of the church, they keep on arguing. But here we made an emphasis here that here we're reading on page 9 on line 3 at the very end. It says, here the identities of those making allegations against the defendants is already known. And then they proceed with saying, these allegations have been the subject of litigation for the past 7 years. The alleged victims have already sued Mr. Garcia twice in both state and the federal court, and some have produced and distributed videos and documentaries to air their claims. So they're stating that these victims have gone on documentaries.
And these are the Nazon's lawyers.
These are Nazon's lawyers stating that these victims, they've been on documentaries. They've come in distributing videos. They have also produced video in different videos. Anyways, we're just making an emphasis on that, and she was trying to explain it. She explained it in Spanish, and I just want to bring here to the English audience. Thank you.
Okay.
Go ahead.
You're welcome.
It is likely that the grand jury was presented with a constitutional invalid theory of liability that violates the First Amendment pursuant Ballard or Hall Church. Additionally, it is likely the grand jury was presented with a theory of spiritual coercion. This is very important right here. The spiritual coercion. So they're stating in here that most likely they believe, this is what they believe, that they violated the Ballard or the Hall Church rules.
Okay.
Because they believe that they use the theory of spiritual coercion as part of the accusations. So they're stating that if they use those spiritual coercion, that basically they are violating those rules that were already determined by the court, that they cannot be ruled that if a church or the organization is true or false. Right? We're gonna go more into it.
Right. Wow. Okay.
That the assertion that the individuals engaging in sexual conduct with the defendant because they believe they will be spiritual consequences to refusing, saying no paves the path to hell, while saying yes paves the path to heaven. So that's where the spiritual coercion. Remember, we read in the indictment where they state that they were coerced and they were manipulated, that if they went against the apostles' will, they can go to hell. If not, or their family could be condemned to hell. Right?
And if they do, they go to heaven.
Then they could be receive
another blessings
and right. That's what we read, right? So basically, they're stating that they're saying that they use spiritual coercion, and that should not be used. So in sexual conduct to the defendant, because they believe that they would be spiritual consequences to refusing, saying no paves the path to hell, while saying yes paves the path to heaven. There is no legal authority supporting the claim that the evidence of such a mental state among participants in sexual activities is sufficient to support a legal claim that those activities were coerced or involuntarily. The government almost certainly presented such testimony to the grand jury, along with instructions about the elements of the charge offense. That would require the grand jurors make a determination that the inter alia. What is the inter alia? This is what that is. One or more religious doctrines taught by the defendants of the church was false or fraudulent. One or more religious doctrines taught by the defendants was corrupted or manipulated and was not the true doctrine of the Luz del Mundo Church or LLDM Church. Coercion, including spiritual coercion, namely the belief that the accusation is sexually advances the church leader, is a blessing that confers to divine favor. So basically, they're saying that most likely they told the jurors, the grand jurors, that the religion that basically they determined that inter alia is that one or more religious doctrines taught by the defendants or the church was false or fraudulent. So they are claiming that they told the juror that the church is false or is fraudulent. So if they the government, when they presented their evidence,
that's what they're saying. They probably did.
They probably did. That's what they probably did. So if they did that, that was wrong.
Oh, okay.
Second, that the more religious taught by the defendants was corrupted or manipulated and was not the true doctrine of the LLDM church, meaning that they changed the doctrine of the Luz del Mundo church, which they cannot decide if the church of the Luz del Mundo church has a true doctrine or not. The true doctrine. There's somebody, I know, so we know that. Is the true doctrine is not true doctrine. Like that argument they were giving me.
Or
third or three, coercion includes spiritual coercion, namely the belief that the acquisitioning to sexual advances of the church leader is a blessing, and that confers divine favor.
Wow.
So
let me read
you want
that.
to read that?
Yes.
It is a core and long-standing component of our First Amendment jurisprudence that the first two types of findings above are categorically prohibited for any court, jury, or governmental entity. And the third category, spiritual coercion, is completely lacking in any legal basis or authority. If the government presented such evidence or testimony to the grand jury, then the indictment is based on a constitutional invalid theory of liability and must be dismissed. Like you said, this issue can and should be raised and decided before trial rather than after trial. The government estimates 2 months for its case in chief, and the defense case will be at least as long as the government's case. So basically, they're saying it's going to take about 4 to 5 months if they go to trial. So they want to raise this issue before the trial, which was already set for March of 2027, right?
Mm-hmm.
So they're just bringing this up here. The question of whether the theory of liability passes constitutional muster should be litigated in the forthcoming motion to dismiss to be filed in July. It is not in the interest of justice to put the defendants through a year-long pre-trial process followed by a 3-month or longer trial based on a theory of criminal liability that may well be unconstitutional.
So they're trying to dismiss the case before it goes to
by July. They were trying to see they can dismiss the case by July. So that's what they're trying to do. They're trying. So it says right here, the question of whether the theory of liability passes constitutional muster should be litigated in the forthcoming motion to dismiss to be filed in July. It is not the interest of justice to put a defendant through a year-long pre-trial process followed by a 3-month or longer trial based on theory or criminal liability that may well be unconstitutional.
Basically, to put him into judgment, even knowing that it might be inconstitutional.
Right. Unconstitutional.
Why should we get him into the whole year? But we can just cut it right now.
In July. By July, we can finish with this. Right? The forthcoming motion to dismiss will be based on the fact that the indictment alleges that the doctrines and the teachings of the church are themselves criminal acts, constituting and furtherance of a century-old criminal conspiracy. And the indictment alleges that Nason Garcia, his father and grandfather, exploited spiritual coercion in order to obtain sex. This theory is legally deficient for at least 3 reasons.
Wow.
1, it does not fit within the list of RICO predicate acts. 2, it does not constitute sexual assault under established legal definitions of. 2, it does not constitute sexual assault under established legal definitions of sexual assault. And 3, it violates the First Amendment rules established by Baylor and Hall Church. Additionally, the Mann Act allegation in count 4 is legally deficient under Mortesian versus United States. The independent fails to support venue in the Southern District of New York. Want to read to them? So, indictment allegations. Indictment allegations that the defendants, known and unknown, abuse the power doctrine and the structure of the Luz del Mundo Church to threaten, coerce, and sexually abuse girls, boys, and women in the LLDM Church. Indictment Part 1. The indictment attempts to squeeze the square peg of threaten and coerce into a round hole of spiritual teachings about salvation and damnation. For 50 years, RICO extortion has meant obtaining something of value through threats of violence. United States versus Hayden in 2024. But what is alleged in the indictment is very, very different. The indictment alleges that the threats were implicit spiritual threats, but not getting into heaven, and that the coercion was thus spiritual coercion based on the fear of not getting into heaven. But spiritual coercion is not a recognized legal concept. It is not a RICO precedent, and its deployment of a theory of criminal liability is not constant with the First Amendment. No case has ever held that a person commits extortion by telling people that giving money to the church will help them get into heaven. No case has ever held that a person commits extortion by telling people that giving money to a church will help them get into heaven. It was precisely that prosecutorial theory that the Supreme Court emphatically rejected in Ballard. Despite 80 years of settled case law, the government is attempting to resurrect that theory here.
No, keep it going.
So basically they're saying that no one can say that you give money to the church that will get you into heaven. If you give money, so basically in that case, in the Bald case, they stated that the church was saying that if they gave money to the church, will they get to heaven? Well, the Constitution in the Supreme Court basically said no. That's
right. But this is what the lawyers are telling the court, the accusations, and when they mention that they were not supposed to mention about faith.
Faith.
So basically saying, are we basing this is accusation. This is what they're saying about faith and about all that. So in part 1, part 2, whatever, paragraph 1.
So now they're going to incite different paragraphs of the indictment.
That's what they're doing.
So on paragraph 7 of the indictment, it is a list of purported teachings of the LLDM church doctrine, including absolute obedience to the apostle, salvation for doing whatever he wants, and damnation for disobeying him in any respect. So those that followed us and we read the indictment on paragraph 7, that's what paragraph 7 states. On paragraph 8, alleges that Aaron, Samuel, and Ason, grandfather, father, and defendant, exploited, manipulated, and corrupted the culture of the church. On paragraph 14, alleges that among the predicate criminal acts are drafting and disseminating sermons and reinforcing the LLDM church doctrine that doubted the apostle was a sin punishable by eternal damnation. We read that. In paragraph 23, defines the criminal purpose of the criminal enterprise as including enriching certain members of the Joaquin LLDM enterprise, securing absolute loyalty and obedience from members from the Joaquin LLDM enterprise and the LLDM church, and preserving, protecting, promoting, and enhancing the power and the influence of the Joaquin LLDM enterprise.
Okay, stop there. Let me go ahead.
Okay.
Yeah.
Okay, so I can read. Yeah, I can continue reading. That's on page. You have to change the page, I think.
Okay. 14.
So page 14.
Ahí está.
Yeah. So paragraph 14A lists among the means and methods. Remember, we read means and methods, right? Under means and methods of the enterprise, providing the victims with, among other things, the promise of religious blessings and eternal salvation, and the avoidance of eternal damnation. On paragraph 24C, lists among the means and methods of the enterprise maintaining control over the victims by manipulating and abusing the culture of the LLDM church, which taught absolute obedience and the devotion to the apostle. Having been raised in the LLDM church, the victims believed that the serving the apostle will lead to religious blessings, whereas questioning, doubting, or disobeying the apostle was a sin that could lead to eternal damnation. Paragraph 24C lists among the means and methods of the enterprise that one of the methods used to manipulate and coerce victims was by holding out the promise of blessings if they submitted to the abuse and the threat of the ostracization and eternal damnation if they resist Nason or his father. Paragraph 24G lists amongst the methods and means manipulating and coercing them through the enterprise corruption of LLDM church doctrine. These members of the LLDM church believed that they would suffer ostracization and eternal damnation if they did not comply with the orders.
Keep on going. It's only half one.
Paragraph 24K lists among the means and the methods of the enterprise repeatedly directing pastors of the LLDM church to deliver sermons calling victims who had come forward liars. Paragraph 25 alleges that the racketeering conspiracy, under the racketeering conspiracy, right? Remember, we read, kind of those that were following us, we read under the racketeering conspiracy, charging this case began on about October 15, 1970, when defendant Nason Garcia was 7 years old, and defendant Selem Nunez and Azaler Rangel had not even been born, and continued through at least in or about August of 2025, by which point defendant Nason Garcia had been in custody for more than 6 years, since his arrest in June of 2019.
Wow. So the first time was what, 1997? No.
Of October 15,
1970. Oh, wow. Okay, déjame leer ahorita. Dice...
But that's, Nason wasn't 7 years old in October of 1970. Nason was only 1 year, he was only 1 year old.
Yep, they have that wrong right there.
And he was not 7 years old.
Wow.
In October 15, 1970, Nason was just 1 year old. But they stated he was 7 years old. That's, I'm reading what it's saying.
Right. Okay.
So they had a conversation with the government, right?
Right.
So they're claiming that they did have a conversation with the government, and this is what their conversation with the government. So the discussion with the government, the parties have met and conferred regarding this motion and exchanged correspondences regarding the arguments made herein. The government's position is that the disclosure of the grand jury's transcripts and exhibits is not warranted for the following reasons. So basically, they're saying that the government is stating that they don't need to receive the grand jury transcripts, and this is the reason that they're giving. They gave to Nason's lawyers, so they already have conversations. So they've been having.
So Nason's lawyers like, we need those transcripts, and the government, the fiscal says no, you don't need to. Right. This is why you don't need the government.
Right, and this is the reason they stated to them that they don't need the transcripts.
Okay.
So A, to the extent you move to dismiss the indictment on the grounds that it is allegations of coercion violate the First Amendment, you do not need grand jury transcripts to make that point. So if you want to say that you need the indictments that we use, we violated the First Amendment, you don't need the grand jury transcripts to make that point. You don't need them. If that's what your argument is going to be, well, you don't need.
Keep on going.
Keep on.
Okay.
Keep on going. You don't need the transcripts. That's what they told Nason's lawyers. B, to the extent you move to dismiss the indictment on venue grounds, an indictment need and only allege facts sufficient to support venue to survive such an attack. So remember, we're gonna read about what the venue grounds is about. We're gonna read about it, but they haven't really clarified what that is. What they're saying that this indictment this case shouldn't be trialed in New York. That it should be trialed in California. But we're going to read about it right now. This is B. On section B, they're saying, to the extent that you move to dismiss the indictment on venue grounds, venue means the location. The court is in the Southern District of New York.
Mhm.
If you want to dismiss it because we are trying this case in the Southern District of New York, an indictment need only allege facts sufficient to support venue to survive as such an attack. Meaning, all they need is an indictment. That's all they need. They don't need all the others. All they need is just an indictment in order to take this case to trial in New York. That's all they needed, and that's what they have. They have an indictment.
Mhm.
C, to the extent you move to dismiss the indictment based on how it defines the alleged racketeering enterprise, the indictment itself is all you need. So all you need is an indictment. They're saying that that's their argument that they're saying. You have all the information you need. You don't need to get the grand jury transcripts. And D, your claim that the government is using grand jury subpoenas for trial preparation is incorrect. In any event, that would not be grounds to dismiss the indictment, which the grand jury returned before issuing the subpoenas you reference. So once again, these are quotes. The reason they're in quotation marks, audience, the reason it's in quotation marks, because these are actual quotes that they received in the emails or in the conversations they had
with the fiscal,
with the government. So this is what the government is telling them. Your claim that the government is using grand jury subpoenas for trial preparation is incorrect. In any event, that it would be grounds to dismiss the indictment, which the grand jury returned before using the subpoenas you reference. They reference. We're gonna keep on reading. There's things right here they're touching on that we haven't touched on yet, but we're gonna read that they did subpoena 11 persons from California to come to New York. But now they're stating that they're saying that those were subpoenaed after the indictment. So they're saying you don't need. If you're claiming that your claims that the government is using grand jury subpoenas for trial preparation is incorrect, and in the event that it would be grounds to dismiss indictment, which the grand jury returned before using the subpoenas you reference. Finally, C, as to and the government contends that the defense does not allege any misconduct in the grand jury proceedings. The defense will address these arguments herein and respond in its reply brief to the aberration of said arguments of the government opposition brief. In summary, first, the misconduct alleged in the presentation of the grand jury of a legally invalid theory of the criminal liability, Bank of Nova Scotia versus United States, and the misinstruction of the grand jury, United States versus Peralta. These issues pertain to the government's theory of coercion and its definition of the RICO enterprise. Second, there is a particularized need for grand jury transcripts as to the venue issue, because the factual allegations supporting the Mann Act charge on count 4, the only allegations supporting venue in the Southern District of New York, are likely deficient under Martesian versus United States. And disclosure of the grand jury transcripts is necessary because the individual identified as victim 7 gave 2 lengthy interviews to law enforcement and never mentioned anything like the factual allegations supporting count 4. The government contends that an indictment need only allege facts sufficient to support venue, but based on the discovery the government has produced, no witness actually alleged such facts. Finally, it is settled law that the use of grand jury subpoenas post-indictment for trial preparation is impermissible. Here, since the indictment was returned, the government has served at least 11 grand jury subpoenas for indictments, for documents and testimony related to this matter. The only way to determine the appropriate remedy is for the court to examine the relevant grand jury records to see what the government was doing. United States versus Peralta, and is right on point. So I'll stop there.
Mm-hmm.
Disclosure of the grand jury material is warranted under Rule 6 because it is necessary to support Mr. Garcia's colorable motion to dismiss. They want to they want to dismiss. They're working on trying to dismiss it. So, number one, summary of the arguments to be made in the motion to dismiss or to strike. Defendant's forthcoming motion to dismiss and or strike to be filed by July 24, 26 per the court order. Will argue that the core spiritual coercion theory that underlies the indictment violates the First Amendment and is unconstitutional. So they want to file it by July 24, 26 to dismiss or strike this whole case. That's what they're trying to do. So here we go. The indictment is based on a spiritual coercion. Theory is unsupported by law, is unconstitutional, and the grand jury transcripts are necessary to preserve and to present the constitutional argument to the Second Circuit and the Supreme Court. The indictment charges that beginning 100 years ago in 1926, defendant Nason Garcia's grandfather, and then his father, and then Mr. Garcia, all three of whom serve as the apostle or spiritual leader of the Luz del Mundo Church, coerced or manipulated women into sex acts by promulgating or having others promulgate the religious doctrine that engage in sex acts with the apostle is a blessing that would enhance one's spiritual stature before God and help one get into heaven. These alleged doctrines, beliefs, and teachings are charged in the indictment as predicate criminal acts supporting the RICO charge. The indictment, however, is vague about how exactly this promulgation or teaching occurred, who allegedly said to whom. The indictment does not say. It is important to know exactly what testimony or documentary evidence the government presented to the grand jury to support this theory of criminal liability, because the theory is likely unconstitutional under United States versus Ballard of 1944. It is pulmonary. The defendant in Ballard promulgated the belief that Jesus had appeared to him at the summit of Mount Shasta and granted him the power to answer prayers. He publicly announced that Jesus had given him this ability and offered his services for a modest fee. The government indicted him for fraud. The fraud prosecution depended on the proposition that his belief that Jesus had granted him the power to answer prayers was false. And such a proposition, the Supreme Court rule, is one of the First Amendment's ability prohibits any court or governmental entity from making ID at 84. If Ballard's statement was true, then no one was frauded. And no one in government, whether prosecutor or court or jury, is permitted to say whether it's true or false. So that is what happened in the Ballard case, that this person that Jesus granted him the power to answer prayers, and then he charged a price, and he was found. the government indicted him for fraud. But that's what they indicted him. Now, what they found, the Supreme Court ruled that they couldn't decide whether it was true or false. So if he could charge, and the ones that believe, they believe. Basically, that's what the government said. We cannot define if it's true or false, if God talked to him or not talked to him. So we're not here, So the ballot issue arises because the government relies on a spiritual coercion theory of liability. The government alleged that the reason that the woman in the church for 3 generations had sex with the apostles was that the apostles, directly through intermediaries, promulgated the religious doctrine that having sex with the apostle smoothed the road to heaven, while refusing smoothed the road to hell. The question is, how could the promulgation of such a doctrine, and for the purpose of this motion, we address that the government's allegation that this doctrine was promulgated, and do not coincide with that the government can prove that the allegation at trial constitute a crime. That crime act does one. What crime act does one commit by telling such things to people? What criminal act does one commit by telling such things to people? For virtually all of the alleged sex acts, the theory of coercion and threat is purely spiritual one, accomplished through the promulgating of this doctrine. The coercion that renders the alleged sexual conduct wrongful is the alleged promulgation of a religious doctrine that it is a blessing in the eyes of God to engage in sex acts with Joaquin Garcia. I'm sorry.
¿Dónde estás? En página 20.
I'm on 20.
20.
But this theory lacks any basis in statutory law or case law. There is simply no legal authority that a sex act between adults becomes a crime if one of the adults engages in the act because she believes it is pleasing to God and will get her into heaven. It is therefore crucial for the court and Second Circuit and the Supreme Court to see what the grand jury witness said. If they said in sum and substance that they engaged in sexual activities with the defendant because they believe that the defendant was endowed with spiritual or divine power or favor, such that having sex with him conferred a spiritual blessing, then we are all forced with the ballot.
Ok, para ahí. Déjame poner al tanto lo que está diciendo aquí. Está muy interesante. Dice.
So if she has sex, anyways, go ahead. So if she has sex, basically saying she has sex doesn't mean that she did it because it was a blessing. She had sex because she wanted to be with him, basically. That's what they're saying.
Yeah.
In short,
Okay.
they're not saying that it didn't happen. They're saying that if she had sex with him was because she wanted to be with him. The question is how the promulgatory of such doctrine and the purpose of the motion be addressed the government allegation that the doctrine was promulgating and not concede that the government can prove the allegation at trial constitute a crime. What crime act does one commit by telling such things to people? For virtually all the alleged sex acts, the theory of the coercion and threat is purely spiritual one, accomplished through the promulgating of this doctrine. The coercion that renders the alleged sexual conduct wrongful is the alleged promulgation of a religious doctrine that it is a blessing in the eyes of God to engage in sexual acts with Joaquin Garcia. But this theory lacks any basis in statutory law or case law. There is no legal authority that a sex act between adults becomes a crime if one of the adult engages in the act because she believes that it's pleasing to God and will get her into heaven. It is therefore crucial for the court and the Second Court and the Supreme Court to see what the grand jury witness said. If they in sum and substance that they engaged in sexual activities with the defendant because they believed that the defendant was endowed with spiritual or divine power or favor, such that having sex with him conferred a spiritual blessing, then we are all forced with valor. In short, the defendant intends to argue that the government cannot constitutionally bring this case to trial on the theory that it constitutes either fraud or coercion for a defendant to say or have others say that God smiles on those who have sex with him. If the Constitution forbids prosecution of a religious leader for getting money from church members by exploiting their beliefs in his spiritual power and authority, then it equally forbids prosecution of a religious leader for getting sex from church members by exploiting their beliefs in his spiritual power and authority. The indictment makes numerous vague and unspecified references to coercion. Coercion.
What page are you in, Beck?
Page 21.
Love you too.
But based on this discovery, the primary and in instances sole modality of coercion is the alleged religion's doctrine that it is a blessing to have sex with the apostle. If such testimony was presented to a grand jury, and or if the prosecutors instructed a grand jury that sex under such a belief is ipso facto coerced, then the grand jury indicted under a allegedly invalid theory.
What page are you in?
21. Dismissal of the indictment is a proper remedy for presenting an invalid legal theory to a grand jury. United States versus Peralta. The AUSA improperly instructed a grand jury on the legal standard for consecutively possession. The court held that because the defendants were seriously prejudiced by the cumulative effect of the government's misleading statements of law, and that the erroneous instructions gave doubts as to the entire indictment. The court dismissed the indictment, concluding as follows: we, the defendants, were seriously prejudiced by the cumulative effect of the government's misleading statements of law and its use of inaccurate hearsay testimony. Dismissing indictment based on government's reliance on false and misleading hearsay testimony. These defects in the grand jury leave us with a grave doubt, and the decision to indict was free from the substantial influence and errors. See Bank of Noscova versus United States. In Peralta, the government told the grand jury that a particular legal doctrine applied to a particular set of facts to support legal liability. The government instructions were wrong. The set of facts does not, in fact, give rise to legal liability. In Peralta, the legal doctrine at issue was constructive possession. In the instant case, it's spiritual coercion. The instant case is all fours with Peralta. The government misinstructed the grand jury and gave an overbroad definition of coercion, just as in Peralta, the government gave the grand jury an overboard definition of constructive possession. The government charges that the defendants promulgated the doctrine that having sex with an apostle was a spiritual blessing, and therefore persuade women to engage in sex acts with him. The government makes no attempt to separate any allegations of actual threats of force, if it has any or none as specifically alleged, or sex acts with minors, which would be per se criminal acts. for the generalization spiritual manipulation theory. Moreover, and the defense will argue fatal to the RICO charge, is that the criminal conspiracy alleged to the promulgation of a doctrine that persuades women that having sex with the apostle will help them get into heaven. So, if the government were to allege that specific sex acts were engaged in using force or threats of force, that would not be a First Amendment issue, but the indictment does not make such allegations.
Mm-hmm. If the government,
so the question is force on this court, and then on the second court and the Supreme Court, most likely. Does our Constitution permit the government to charge the promulgation of religious doctrine as a crime? That's the question. And then you can continue. So the indictment is based on a corruption of true church doctrine theory, which is unsupported by law and is unconstitutional, and the grand jury transcripts are necessary to preserve and present this constitutional argument to the Second Court and the Supreme Court. The indictment charges that the defendant were part of a criminal conspiracy led by the leaders of the Luz del Mundo Church to corrupt and manipulate the doctrine of the church in order to procure sexual partners for this church apostles. Defendant Nason Joaquin Garcia, and the indictment charges his father Samuel Joaquin and his grandfather Aaron Joaquin. The indictment specifically alleges that the primary modality for procuring sexual partners was to promulgate church doctrine teachings that the apostle was the spokesperson for God on earth and was thus without sin, and that satisfying his desires would put a person on the path to heaven, while refusing would put a person on the path to hell. See indictment paragraphs 24A and C. The indictment alleges that these teachings was a corruption and manipulation of the church doctrines, and its promulgation is alleged as a predicate criminal act. See indictment paragraph 8. But under Hall Church, courts are expressly precluded from engaging in any departure from doctrine, analysis, or rulings. A court simply may not find, as the indictment charges and requires the court to find, that the church leaders or officials corrupted or manipulated religious doctrines. It is therefore crucial for the forthcoming defense motion to see exactly what testimony and evidence were presented to the grand jury regarding doctrine and corruption thereof.
So once again, they're trying to get documents from the grand jury to make sure that nothing of that is used back then
in order to
do the
to get the indictment approved. Right. So go ahead, read.
Okay.
So venue in the Southern District of New York is supported only by count 4, the factual basis of which, in absent from the discovery, production, and the grand jury transcripts, are necessary to preserve and to present the constitutional argument to the Second Circuit and the Supreme Court. Count 4 alleges that in January 2017, Mr. Garcia persuaded, induced, and enticed a person identified as Victim 7 to fly with him from South Africa to New York. Indictment paragraph 34. Victim 7 is not alleged to be a minor, nor is there any allegation that any threats or force were used. There is no allegation that Victim 7 was employed as a prostitute or engaged in any commercial sexual activity, and there is no allegation that the physical force or threats of physical force was used to persuade or coerce Victim 7 to get on the plane and make the trip. Instead, the allegation is that Mr. Garcia engaged in unlawful sexual activity with Victim 7 in violation of New York Penal Code, New York Penal Law. The indictment does not say what the alleged unlawful sexual activity was, nor where or when or even where it allegedly took place. It simply cites various New York Code sections: 130.35 forcible rape, 130.50 forcible anal or oral sexual conduct, 130.25 sexual conduct without consent, 130.40 sexual conduct without consent, 130.55 misdemeanor sexual touching without consent, and 30.52 misdemeanor forcible touching. Indictment paragraph 34. The indictment's vagueness on this point warrants production of the grand jury transcripts, because the Mann Act theory is very likely deficient as a matter of law under Mortensen versus United States. An interstate trip that evaluates in or includes a criminal sexual act does not hereby become a Mann Act crime. It is crucial for the court to review exactly what this individual listed in the indictment as victim 7 told the grand jury. If she told the grand jury in sum and substance that Mr. Garcia enticed her to travel with him to the United States from South Africa, and then once they arrived in New York, he sexually assaulted her in some unspecific way that, based on the government list of New York statutory sections, could have been anything from unwanted touching to forcible rape, then the allegations fail to define a Mann Act crime as a matter of law. Disclosure of the grand jury transcripts is crucial on this point, because the individual victim identified as victim 7, in fact, gave 2 lengthy interviews to law enforcement. She never mentioned a South African trip. What this individual, an adult at all relevant times, said in her interview was that the church offered her a position on a traveling missionary, and she accepted that position. She said that as part of her missionary duties, she accompanied Mr. Garcia on various overseas trips over a period of several years. She said that periodically during those trips, he made sexual advances. She said that she acquisitioned because she believed it would be sinful to refuse, given his status as an apostle of the church. If she said the same in sum and substance to the grand jury, the government instructed the grand jury that the narrative constitutes a Mann Act crime, then the government misinstructed the grand jury on the legal issues as well, and the grand jury indicted on an invalid theory.
That's where I stopped.
It has been settled law for 80 years that Section 2422 does not criminalize every interstate trip or trip into the United States simply because criminal sexual conduct occurred during or after the trip. Nor does it matter if the criminal sexual conduct was ongoing prior to the trip and was anticipated to continue during or after the trip. That is precisely what Mortensen versus United States holds in 1994. The Supreme Court teaches in Mortensen that the statute only criminalizes the indictment, entices or coercion of a person to make a trip of the purpose of engaging in a criminal sex act. In Mortensen, 2 women were working for the defendants, a married couple who ran a brothel in Nebraska, as prostitutes. The couple was planning a vacation, and the 2 women asked to come. They worked as prostitutes up until the interstate vacation and immediately resumed working for the defendants as prostitutes when they returned from the interstate vacation. The question the Supreme Court was faced with was, does that mean the trip back home from Utah to Nebraska, which everyone in the car understood was going to be immediately following the 2 women resuming their work as prostitutes for the defendants, is a criminal interstate transportation under the Mann Act? The Supreme Court emphasized answer was no. No, it is not criminal interstate transportation under the Mann Act. The fact that the criminal sexual activity may occur before, during, or after the trip does not entail that the criminal sexual activity was the purpose of the trip. And here it is undisputed that the purpose of all the foreign trips on which the individual referenced in count 4 was included was the evangelical missionary outreach of the church. Just as in Morrison, the fact that the criminal sexual act alleged occurred before, during, or after each trip does not convert the trip into a Mann Act crime.
Or yet.
On 20 at the very bottom.
Okay.
This issue will be crucial for the forthcoming motion because Court 4 is the only court that can support is the South District of New York venue. As the court is aware, this is a Los Angeles focused case in which almost all the acts, residents, witnesses, and evidence were and are in Los Angeles. It imposes great cost and inconvenience on defendants for the case to be in New York. There is no practical reason for it to be in New York. The only legal support for New York venue is the very thin bro of count 4. Thus, it is a crucial to the motion to dismiss is to see exactly what victim 7 said in the grand jury. We do not know what she said about this South African trip, if anything, because there is nothing in the discovery about it, and she does not mention it in her interviews.
Wow. Okay. So.
And let me just finish it. Based on this theory, it would appear that if victim 7 said anything about a South African trip, she likely said in some substance that she was part of Mr. Garcia's entourage for certain foreign trips, including a trip to South Africa, and that she alleges that he allegedly assaulted, presumptively pursuant to the spiritual coercion theory during those trips. If that was her testimony, then count 4 must be dismissed because it was based on an invalid legal theory.
Okay, let me explain to you real quick what is the Mann law. Mm-hmm. The Mann Act. Okay. This is the Mann Act, officially called the White Slave Traffic Act of 1910. Makes it a crime to transport someone across state lines
to have sex
internationally for illegal sexual activity.
Right.
It basically says you cannot move, take, or arrange travel for a person from one state to another for prostitution or illegal sexual purposes. What prosecutors must prove to charge someone under the Mann Act, they generally must show transportation or travel happened across state lines or between countries. The intent, the purpose of that travel was sexually activity that is illegal, and knowing involvement, the person knew or intended that illegal activity was going to happen. So, right. I didn't know what that law mean.
Right. So yeah,
but I remember hearing about this in the indictment about the crossing lines and other stuff. So I'm gonna read it right now so I can understand exactly what it said in Spanish.
Yeah. So basically, what they're arguing is that the government is alleging the Mann Act in the state that victim 7 was traveled from Africa to New York. And during that time, she was allegedly having sex, but unwanted sex.
But basically, they're saying that having that it should be easier to do it in Los Angeles because it's costing them a lot of money.
No, but they're saying that the only reason that there's being indicted in New York is because victim 7 stated, or she did not state it. According to them, only the government has stated that she was she had sex against her will.
Right, but they're saying that all these should be done in California.
Right.
The lawyers are saying they should be done in California.
Well, yeah,
because it's less expensive and it's like more. Yeah. Okay, but that's what they're arguing.
But they're arguing that the only reason it's in New York was because of victim 7.
So it should be done in California. Is that what I'm saying?
Well, the The only reason that it was indicted in New York was because of victim 7.
Yes.
Right.
But I'm saying,
but all the other victims are from California.
exactly. So they're saying they should be done in California.
That the indictment should happen in California.
Exactly. That's what I'm saying.
That's what the last part. The indictment RICO count is based on a legal invalid theory of what constitutes a RICO organization, and the grand jury transcripts are necessary to preserve and present this constitutional argument to the Second Circuit and the Supreme Court. A RICO charge must allege the exercise of an organization whose purpose is the commission of one or more RICO predicate crimes. The list of RICO predicate offenses is found at 18 U.S.C. section 1961, parentheses 1. The indictment alleges that the following RICO predicate offenses: creation of child pornography, paragraphs 11, 24E through F; money laundering under the structuring theory, paragraph 13, paragraph 14; obstruction of justice, paragraph 14 and 24K; sexual trafficking, paragraph 24 C and D; use of forced labor, paragraph 24G; bank fraud and coercion with mortgage applications, paragraph 24J. Defendants intend to argue that the indictment is fatally deficient because it does not and cannot allege, and no testimony was presented to the grand jury that allege that any of these alleged predicate acts were the purpose of the organization. The indictment alleges that the RICO organizational conspiracy is and was the leadership of the Luz del Mundo Church and the church itself, going back for the past 56 years to 1970, indictment paragraph 25, or 100 years to 1926, indictment paragraph 8 and 9, with the principal conspirators being the three spiritual leaders of the church going back to its founding, in indictment paragraph 8. The Luz del Mundo Church is a global church with more than 5 million members in more than 100 countries around the world, and it is second largest church in Mexico, one of the largest in Southern California, and one of the fastest growing churches in the world. LLDM operates thousands of churches, thousands of schools, and thousands of charitable, educational, and developmental programs around the world. The government cannot, and presumably does not, allege that the purpose of the entire church and its millions of members and its century-long history was and is simply to procure sexual partners for Nason Garcia, his father and his grandfather. This would be like indicting the Catholic Church as a 2,000-year-old criminal conspiracy with the purpose of procuring altar boys as sexual abuse victims by promulgating, manipulating, or corrupting church doctrines. This indictment tries to squeeze the round peg of the entire church and its history and teachings into the square hole of a RICO conspiracy. Everything the indictment says about LLDM and sexual abuse could equally be said about Catholicism and sexual abuse. The two churches should be treated the same. If individuals committed crimes, they should be charged with those crimes. But this indictment alleges a RICO conspiracy consisting in large part of the promulgation of church doctrine and a coercion theory based on spiritual beliefs about salvation and damnation. No such indictment has ever been brought against the Catholic Church or any other mainstream American religion. It would be a first under the United States Constitution for a court to accept as a constitutional legitimate charge instrument or an indictment alleged that an entire religion has been led by a criminal conspiracy for the past 100 years, that every leader of the church has systematically exploited, manipulated, and corrupted its membership, that the volunteer work for the church is criminal forced labor, Indictment 24G, or that the preparation of the sermon saying the accusation against the church leader are false is criminal obstructions of justice, Indictment paragraph 14. The defense requests that before government is permitted to proceed to trial on the indictment that pushes well past long-standing First Amendment guardrails governing criminal charges against churches, the court should order the government disclose the manner in which it secured its indictment. Disclosure of the grand jury materials is warranted because the government is improperly using grand jury post-indictment for trial preparation. It is well settled that it's improper to utilize a grand jury for the sole or denominating purpose of preparing a already pending indictment for trial. United States versus Rafael. United States versus Algeria. In the grand jury subpoena Ducis Tecum, dated January 2nd, 1985. However, a court should not take at face value the government word. The dominant purpose of the grand jury proceedings is proper when the government actions in the grand jury rise to the inference of irregularity of impropriety. In Simmels, the government initially served a trial subpoena on the defendant's attorney seeking documents related to the fee arrangements. The subpoena was served solely for evidentiary purposes to prove an element of the charged offense. When the defense objected, the government issued a grand jury subpoena seeking the identical material and then withdrew the trial subpoena. The defense moved to quash the district court denial the motion and the Second Circuit considering the issue of appeal. The court's inquiry focused on whether the dominant purpose of the government used the grand jury was an mechanism to procure a discrete piece of evidence at trial rather than a neutral pre-indictment investigation fact-finding body. The court concluded that if the rule is to have any meaning, we believe that the subpoena here must be quashed as an abuse of grand jury process and reverse the district court denial of the motion to quash. The Simmels court found the government's dominant use of the grand jury for the purpose of preparing for a trial was improper, and there was only one subpoena in Simmels. Here, government has served so far at least 11 post-indictment grand jury subpoenas. See declaration of Godfrey Neary filed. Herewith the continued churning of grand jury proceedings for a year after the filing the indictment, certain appears to be trial preparation, pure and simple in the circuit. The use of post-indictment grand jury subpoena for trial preparation is not permitted. At very least, an in-camera review of the transcripts and exhibits is necessary to determine the dominant purpose of the government's post-indictment subpoena. Conclusion. For the foregoing reasons, Mr. Garcia respectfully requests that this court order that the grand jury transcripts and exhibits shall be produced to the defense under the protective order previously entered in this case, dated April 10, 2026, respectfully submitted by Workersman, Jackson, and Quinn. There we go.
Okay. Something about it?
Huh?
You want to say something about it? No.
So basically, they're stating that after the grand jury indictment, the government has issued 11 subpoenas to 11
Before.
after. They're saying that it was during. They want to know if it was during, but they're saying the government is saying they did it after.
The government says they did it after, but the defense says they did it before.
It did before.
Okay.
And it was, and if we continue to the next page.
Yeah, I see the bottom page where supposedly it's Jeffy and what's his name? He says that
Godfrey A. Neary states that he represented those clients that were from, and that he's willing to testify, and that's his letter to the included here to the court, stating that he's willing to testify and on behalf of.
Yikes.
So they're stating that he's, as a lawyer, he represented those 11 victims. Mr. Godfrey A. Neri, if you want to put, go ahead and put the letter on next page.
I see that. I see that here.
One more, right there.
That one.
Yeah. This letter is stating Declaration of Godfrey A. Neri. Declare as follows: I am an attorney licensed in the state of California. I make this declaration from the personal knowledge that if called as a witness, I could and would testify completely to the matters of set forth within. In the past 9 months, subsequently to October 1st, 2025, I have represented 11 California resident clients who were served grand jury subpoenas by the United States Attorney Office for the Southern District of New York for documents and testimony related to the Nason Garcia and Samuel Garcia. For the ongoing is true and correct to the best of my knowledge and belief under penalty of pre-jury under the laws of the United States, executed this 8th day of April 2026 at the Los Angeles, California. And this is
wow,
a declaration that he would willing
testify.
to. And then the following is the next page.
I wasn't gonna get there yet, but okay.
We can finish. Well, let me finish it in English, and then you can. So this is the last page. Is where is for the judge to sign the order to release the grand jury indictments.
Yeah, just for
for her signature.
For her signature, and just like, okay, yeah.
It's already
wow.
It's already submitted.
Me preocupa.
No,
me preocupa Jeffrey, whatever his name is, Geoffrey Nori. Me preocupa.
Well, he's also represent in the case of Sochi's case. He's also a
yeah, I know, but he's saying that
he's
willing to testify that the victims were interviewed before the grand jury made the decision. That's what he's saying.
That's what he's saying. Yes.
That's what I'm saying. It worries me because the governor says that it was after, and this guy is willing to come and testify it was before. Well,
that's where we're at. That's where we end.
Yeah.
The government says we don't need the transcripts, and the defense says we do need the transcripts. So who's right? Who is right? Who is wrong? We don't. That's something that's gonna coming up. And lastly, we're gonna end with this. We have the chronicle case of the chronological what this already was presented in court on April the 10th, we received la defensa solicitó la información del gran jurado, so they already solicit. Now now we're going to wait until May the 8th when the government will respond. On May the 23rd, the defense will respond, and on July the 24th will be when the judge will make her decision. So we still have dates here, which is the next date is May the 8th, which is they have until May the 8th to respond to this motion. And then the defense will have till May the 23rd to respond to the government. And then on July the 24th would be the judge to respond to both. So
right, but 24th of July, right? Is when the judge is going to respond to this argument.
Yes.
And then the 23rd of August.
If we continue after the 24th, then the 23rd of August, the government will respond to all the motions. And then on September 11th, there will be another
Nason's reply.
And then on the 23rd, it will be an actual court hearing where they will all have to appear in court. Wow. So this is the dates that we have so far that they've established of when everything's supposed to occur in this court. So I just want to put it up there so that everyone that's following us knows what's going on. And stay up to date. We will be up to date. What happens on May?
We cannot see your face.
Right there.
Oh.
So on May the 8th, the government has till May the 8th to respond to this motion. I want to say thank you for everyone that's here, and thank you for everyone that reaches out. Thank you for everyone that reaches out and has keeps giving us the good vibes that they send us. I do appreciate it, especially those that call me personally and tell me what's going on with their lives and how we are opening up more conversations in their homes with those members that are still in the organization. You know who you are. You know who you are that have reached out and told me that you now having conversations based on our documents that we're presenting. And I also want to thank Virginia Beckett because we have used some of her information that she's translated, some of the documents that she has translated. We've used her and some of that information. Thanks for her providing that information. But
she says we appreciate you taking the time to keep the audience informed.
But we also obtain these documents through the courts and other documents of properties and other things that we bring here. They're all documents that can be obtained through courts or through other entities that are out there to get the information we bring here. But I want to thank everyone that reaches out. Virginia, I did follow you when you were following the state case. I did follow your posts and what was going on. I know you post a lot on that estate case.
Night.
Good night.
Thank
Good
you.
Night, good night,
Hello.
Good night. Thank you for following us. Thank you and leave your like, your shares, and everything.
Bye, chicos. Se portan bien y si no, invitan.
Good night, guys.
Ay, me falta mi outro. Aquí está. Ahí está.
Más de 30 years side by side. Rogelio y Alma, no questions, no lies. Cameras rolling, lights on bright. Working for a vision they call divine. Nos dijeron this is God's will. No questions allowed, just be still. But time don't lie, truth always shows. And cracks appear behind the show. One day we walked away in silence, con el corazón lleno de scars. 6 years out, healing slowly, but the truth followed us wherever we are. We're coming back, but not the same. Con el mismo equipo, different aim. Same hands, same skills, new direction. Now we speak facts, truth, court, protection. We're coming back, no fear, no chance. Con documentos, not just faith. What they hid is coming to light. This ain't revenge, this is what's right. Using the gear we used back then, las mismas cámaras, but now we explain. Mixers, mics, everything they gave, now exposing lies they tried to save. This ain't gossip, this ain't hate, it's court files, dates, federal states. Nowhere's look at Easton from the stage. It's what's written, page by page, yeah. They called us rebels, dijeron traición, but lies don't survive real information. If truth was wrong, tell me why they fight so hard just to keep it quiet. We're coming back, but not the same. Con el mismo equipo, different aim. Same hands, same skills, new direction. Now we speak facts, truth, court, protection. We're coming back sin miedo, oh yeah. La mentira shakes when truth arrives. What they buried won't stay buried tonight. This ain't hate, this is life. We didn't come back for views, no volvimos por fama. We came back because someone has to say it. Y ya no te tenemos nada que perder. We're coming back, standing tall. La verdad no needs permission to call. If it was fake, it's gonna fall. Light always wins in the end of it all. We're coming back, standing tall. La verdad no needs permission to call. If it was fake, it's gonna fall. Light always wins in the end of it all.